The United States Supreme Court has just stepped directly into a massive constitutional clash that could completely upend how criminal justice systems currently operate in some states. If you think that your right to a fair trial is completely safe under the Bill of Rights, you need to watch out because the Supreme Court just granted review to a case that exposes how certain states and governments have been shortchanging that foundational constitutional right. Recently, the Supreme Court agreed to take up a fast-moving challenge known as Keon versus the state of Florida. Now, on paper, this started as a local dispute involving a state licensing case, but now it has become a question of what the founding fathers of our country actually meant when they talked about your right to a jury trial. Currently, 6 different states have been actively bypassing the traditional 12-person jury requirement, convicting individuals using a shrunken 6-person jury. The current conservative majority of the Supreme Court has potentially just signaled that they are ready to completely tear down that loophole, but the fallout from this upcoming ruling is going to trigger a shockwave that impacts all Americans. So we need to break down what exactly is happening in this case and what this means going forward. Now, before we jump into what the Supreme Court is doing in this case, if you like this type of content and you want to make sure that you get it going forward, make sure you subscribe to the channel and also turn on all notifications. I also want to thank one of the main supporters of this channel, which is Attorneys on Retainer. When it comes to self-defense protection, in my opinion, AOR is in a league of their own. They're backed by an actual law firm, the Attorneys for Freedom, and they're always trying to expand upon their benefits to give you as much as possible as a member. So if you're interested, you can check them out using the links down below. And right now, if you use my exclusive code ARMSCHOLAR for a limited time until the end of this month, you can get $50 off of your individual sign-up fee or $25 off of your family sign-up fee. Now, to understand why this case really sent shockwaves through the legal community, we have to look at the bizarre facts that actually brought this case all the way to the Supreme Court. So the petitioner in this case is a Florida resident, a man named Mr. Keon, and he was charged by state prosecutors with multiple felony counts of practicing chiropractic medicine with a suspended license. Now, under normal circumstances in a federal court, if you face serious prison time, you are guaranteed a traditional and robust 12-person jury to stand between you and the power of the state. But Florida, along with 5 other states, including Arizona, Connecticut, Indiana, Massachusetts, and Utah, have exceptions to that rule. For non-capital offenses, they actually will shrink your constitutional shield and your right to a jury to just 6-person juries. Mr. Keon was forced into a trial before that shrunken 6-person panel. He was ultimately convicted and sentenced to over a year in prison, followed by 5 years of probation. Now, Mr. Keon fought back against that, demanding that his 6th Amendment right to a full 12-person jury was actually violated. The State of Appeals, on review of that, actually outright rejected his arguments, pointing to a 1970 Supreme Court precedent and case called Williams versus Florida. Now, in that older ruling by the Supreme Court, a past Supreme Court used a cost-benefit analysis, claiming that a shrunken 6-person jury could be equally effective as a traditional one. But Mr. Keon's legal team then brought this case to the Supreme Court, arguing that this era of watering down the Bill of Rights and your right to a jury, that this era is now over. He argues that the Supreme Court precedent has changed since that prior ruling, and that the court should now officially overrule that prior decision. Now, the question is, why did the Supreme Court grant review to this specific case? Well, that's because Mr. Keon's petition completely corners the Supreme Court using their own modern logic. In his petition for review, Mr. Keon pointed directly to a massive landmark victory from 2020 called Ramos versus Louisiana. In that case, this Supreme Court completely struck down a non-unanimous jury verdicts, ruling that the 6th Amendment must be interpreted exactly as it was understood when the Bill of Rights was adopted in 1791. The Supreme Court in that Ramos ruling explicitly rejected the exact type of cost-benefit analysis that was used by the court in that prior 1970s decision. In this new precedent, the Supreme Court said that it is not the job of judges to decide which historic features of a jury trial are important enough to keep and which ones can be discarded. Mr. Keon's argument goes back to originalist concepts and focuses on the intent of the actual founders. He argues that at the founding of this country, the word jury meant one thing and one thing only: 12 ordinary citizens. So when the people enshrined that right, they did not attach a rider or some sort of exception, allowing future states and bureaucrats to downsize that right to simply save time and money. Now, to show how confident Mr. Keon's legal team is in this current originalist argument, they just filed a brand new motion asking for the Supreme Court to completely dispense with the requirement of a joint appendix. They told the Supreme Court that this is a pure question of law, meaning that the facts of the local arrest do not matter, that the lower court's opinion was completely wrong, and there is zero need to waste time or money compiling a massive mountain of lower court records. Florida isn't even opposing that request, and by dropping this filing, Mr. Keon is essentially stripping away all of the administrative noise and forcing the Supreme Court to look strictly at one thing. Does the Constitution mean what it says when it guarantees a jury trial? Now, this is where this case applies to all Americans and really for you guys, the viewers who are gun owners. So think about this. If the government is allowed to prosecute complex, high-stakes, two-way cases, or maybe technical compliance violations under the NFA, and they can do that before a shrunken 6-person jury, it becomes drastically easier to secure a conviction. It takes far less effort by the state to manipulate or to pressure 6 people into their theories than it does to convince 12 people. Also, this impacts your fundamental rights as an American by watering down what protections the founders intended in the 6th Amendment in your right to a jury trial. Now, of course, Florida's Attorney General desperately tried to stop the Supreme Court from taking this case. They wrote a brief in opposition. The state openly admitted that if the Supreme Court overrules the old loophole that's been used for 50 years, it would instantly imperil thousands of active criminal convictions in Florida and 5 other states that have relied on this type of smaller jury for over 50 years. The government is worried because if the Supreme Court overrides their prior precedent, it would open the door potentially for current or future cases or, active cases right now to be challenged based on the use of 6-person juries. So make no mistake, by granting review, the Supreme Court conservative majority has signaled a massive potential change on a critical constitutional right. They are poised to declare that the states here cannot alter, shrink, or dilute the literal text of the Bill of Rights under the guise of administrative convenience or time or cost savings. The constitutional shield of 12-person juries is on the verge of total nationwide restoration, but until the final ruling drops next term, there's going to be very serious questions, and all of these felony trials or all of these other cases that maybe across the country have been using 6-person juries. Really, that's going to be a legal minefield going forward, and they're going to be wondering what the Supreme Court is going to do. So that is the critical case that the Supreme Court recently granted review on. The loophole has been challenged, and the government is officially panicking because this case was granted review. So I'm going to be tracking this as it develops and as it moves forward this next term. But if you like this type of content and you want to make sure that you get it going forward, make sure you like, comment, subscribe, and turn on all notifications so you never miss these videos when I release them. But as always, thank you so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.